There we go. For anyone on now, we'll get started in about a minute or two. And Danielle, did you log in through the account?
I use the link that you sent me to be a panelist.
Okay, perfect. So you'll be able to see the Q&A.
Yeah.
Can you help me navigate the Q&A if anyone has questions today?
Yeah, absolutely.
Okay. All right, well, it's 9 o'clock. I think we'll get started. Welcome to the Special Education Legal Clinic. My name is Mark Weicker, and I'm here with Danielle Randolph. This is Procedural Rights and Dispute Resolution. It is the 7th and final in our series, A Power to the Parents, and we'll continue with the clinic. We've done so far every second Saturday of the month, and we're going to move that in February, starting in February, to every second Monday of the month. So a new schedule will be coming out, and a new schedule of workshops will be coming out too. So you'll be able to register for the workshops and individual guidance sessions through the link at the bottom there, lawyersforstudents.com/legal clinic. And that schedule should be out within a week or so. And like I mentioned, this is Procedural Rights and Dispute Resolution, the 7th in the series. And the series is posted. Let me advance the slide here. So this series here, workshops 1 through 7 and Power to the Parents, are posted at that same link, the Legal Clinic link. So the video right after today, after today's session, will be posted so that you can watch any videos on demand of workshops 1 through 7. So they are available that way. We'll have a Q&A available. If anyone has any questions, you can drop a question in the Q&A. We prefer the Q&A. If you have to do it through the chat, we can get it there too, and Danielle will help out with that. I think that's it to get started. Yeah. Oh, one other thing, of course, is that this clinic is a partnership between our law firm, Albite Weicker, Disability Rights Ohio, and the Ohio Coalition for the Education of Children with Disabilities. The three of our organizations have come together to offer the content, and we take turns in offering workshops. And I think the next workshops are going to be offered by OCECD. And again, that schedule will be posted soon. Thank you for joining us. If you have an individual guidance session, you'll have a separate link for that scheduled for either 11 or 11:30 today. All right, so let's jump right into it. This is on alternative dispute resolution. So in particular, facilitation, mediation, other dispute resolution. I think a lot of people have heard of or maybe even participated in due process in the past. So this is really about parents and students' procedural rights. What's really cool about IDEA, the law that governs IEPs and special education, is that there is this really broad range of alternative dispute resolution tools available. And just I can say from being a legal practitioner, from being an attorney, I can't think of any other area in the law, bankruptcy, personal injury, workers' compensation, where there are all of these alternative dispute resolution or ADR tools available. You'll see we're going to talk about kind of the spectrum or the array of tools. And what's, I think, advantageous for parents and students is that you can use these tools kind of in sequence, or you can use the tools, by selecting one or the other because of their benefits, which we'll talk about. But it really is driven. The law, unlike a lot of other laws, is really driven so that the parties can resolve their disputes before stuff hits the fan. We'll talk about due process, which is kind of the end of the sequence, but and we'll talk about filing a complaint in court. But there are several tools leading up to that that are available. So it's really a parent's rights and a student rights driven statute, because not only are these tools available typically in the real world or other areas of the law. For mediation, the parties have to pay a mediator, and that can be $1,000 a day, $2,000 for a couple days. So that is not inexpensive. Mediation is not cheap, but through the Department of Education, then ultimately the U.S. Department of Education through IDEA, these alternative dispute resolution tools, facilitation, mediation, so on and so forth, are available to the parents and students for free, which is pretty incredible. A lot of funding flows to the Department of Education to provide these tools. So that's what we're going to talk about today. And so when do we need to use these? When is dispute resolution needed? And dispute resolution is kind of the broad umbrella term that we're talking about, that we will be talking about today, that starts with facilitation on down to due process and filing a complaint in court. But when should these be triggered? Well, it really, they start with number one here, when there's just a fundamental disagreement. When you've said, I think we're entitled to X, and the school says, I think you're not entitled to that. Or the school thinks you should do this, and you think we don't have to do this. So that very broadly speaking, it's when you're at an impasse. That's kind of negotiation language for, look, your position is this, and your position is this, and we're in two different places. And no one has the, or maybe there is some answer in the law as to who's right, but the other party's not budging, basically. So you need some help. So when you're at an impasse, let's say, for example, you believe the appropriate placement is outside at another private school, and the school says, no, we can accommodate the student here in-house. And if you've asked, especially if you've done that in writing, and they disagree, then it's time to get some help, through facilitation or mediation. Number two, so when all other options to resolve the matter as a team have been exhausted, you're not going to get anywhere if you just have a disagreement and you haven't really submitted that in writing or made it clear to the district. You haven't raised it in an IEP meeting, and then you just file a state complaint on it. I mean, you may ultimately get the result, but you're going to break down the relationship. So you have to exercise the other methods to get to a resolution. That would be, of course, an IEP meeting. Like, go to the IEP meeting, explain what you want and why you want it, and why you think you're entitled to it. And if the school district, either in the meeting or through the PRO1, is telling you that they're going to deny that request, then you've at least made the request and they've given you a written denial. So they can show them that you're at an impasse, or at least have an issue that you can research and get some authority from the law. Another thing you might have done, all other options. Sometimes this works, sometimes it doesn't. I would say more likely than not, it doesn't. But there is something called an administrative review that you can use internally at the school district. If let's say you have a fundamental disagreement and the special education director is holding firm, there is a procedure called an administrative review where you can get, it's typically the superintendent, although they can designate somebody to sit in and hear that, but they have to hear your complaint and then resolve it within 20 days. And that can work on occasion. It's kind of, before we get to all the other dispute resolution options, that is one thing that you might want to try if you think the superintendent is knowledgeable enough about special education, and then, may agree with your position. It may be worth an administrative review, although that's not required to go on to any of the other tools. So that relates to number 2, just options to resolve it, prior to using ADR. Okay, then when
I was gonna jump in real quick and just say,
yeah,
in my opinion, the administrative review is typically not very helpful. Just because 9 times out of 10, the superintendent designates a special ed director to really, take control of special ed and to be that person who's knowledgeable about special ed. Like you said, the superintendent usually is not. So in the instances I've had where we've tried that, it doesn't go anywhere. So I don't know if you had success, but I have not with that.
yeah, I actually have the same opinion, and I didn't. There may be occasions where superintendent would, just disagree with the special education director, but you're right. Generally, if the decision's being made by the special education director, the superintendent will affirm that. Although it might just be another avenue, prior to pulling the trigger on facilitation or mediation that you could try. But yeah, I agree with you, Danielle. And then 3, when nearly immediate intervention is required. So this is where, again, this relates to number 1, because you're at an impasse, and then whatever's continuing, whatever you're not receiving or whatever's happening, let's say it's a failure to provide the minutes for physical or occupational therapy or speech, or let's say it's a placement that you believe is inappropriate. So it's immediate intervention is needed, because if it continues, then educational or other harm will accrue to the student. So that's where you say, okay, I need some help. We need to budge here. We can't just stay at this impasse. So those are the reasons. Now, these come up all the time, and I think it's important to point out that it's called dispute resolution, but look, these are tools that are available. Just because you get a facilitator involved or a mediator, or even just because you file due process, doesn't mean it has to be contentious. You have a fundamental disagreement, but it will be resolved. And IDEA is a complex statute. You're talking about IDEA, the federal law, the Ohio operating standards, which are parallel, and then also provide some detail on how Ohio implements IDEA. So when you have a disagreement, the reason all these tools are here is because it may not be clear who's right, or the school district may not know that it's a violation of the operating standards or IDEA. So just because you use these tools doesn't necessarily turn it into an adversarial proceeding. Dispute resolution, is the name, the broad name in the law for avenues to resolve it short of court. But that doesn't necessarily mean that it has to be adversarial. And here is kind of what we consider dispute resolution in special education and the progression. And you can jump to any of these, and again, we're going to talk about the benefits and the limitations on each one of these. But for the most part, you could jump to any one of these if you want, but they are set up in kind of progression or an array, so that you can work through it if you have to. And I would say, if we're really talking about the whole spectrum of dispute resolution, of course, you start with the IEP meeting, like I mentioned. So there's really, 0.5 on here would be the IEP meeting, and then maybe the administrative review if you think that's going to get you anywhere. Again, I think a lot of people have the same opinion that Danielle and I do, is that it may not get you anywhere, it may not be worth doing, but it is, the 20-day timeline can be helpful sometimes. You just try it, and if that doesn't work, then you move on to the next step. But assuming you've done those things, you've articulated what you want or what you think you're entitled to the team, and the team disagrees with you, then I think it's time to move into the progression. And one other point is these tools, all of them, are only available when we're talking about a violation of IDEA or the IEP. There may be some support or guidance, I guess, given by either the early resolution, facilitation, or mediation process in navigating a 504 claim, an accommodation that's made under Section 504 or on a 504 plan. But for the most part, the jurisdiction and the funding for these tools comes from IDEA. So the limits on these tools are that they're interpreting and helping you resolve complaints that flow from the IEP or under the statute, under IDEA. And I think you'll see when you get farther down in the state complaint and due process, you will absolutely see that they don't have jurisdiction to hear issues that aren't related to IDEA. We'll talk a little bit more about that, but that's important to understand. Okay, well, let's talk about early resolution. So this is really one of the lesser used tools, but I think very effective. Effective whether or not you're going to facilitation, mediation, or due process. It's just because the people who answer this phone at ODE are really saints. They will listen to your issue, give you some feedback. If they're not sure, they'll call you back. The reason I think this is so important is because it helps parents get to the rule. There's so much floating around out there about what schools are required to do, what their obligations are, what they did with somebody else's student, that a call to this early resolution office will really help you narrow it down to what is the school's obligation in a situation like this. And typically they give you some pretty good support, and it helps you get to the rule. So if you're going to move on down the line and dispute resolution, at least you're going to have a portion of IDEA to point to, or a portion of the operating standards to point to. So what'll happen is that when you call the number, an education program specialist will provide some explanation about the laws that apply as federal and state, so IDEA and the operating standards, and describe the options available to you, so that if you need some additional information on mediation or state complaint or due process, they can provide that. And then they also help identify whether or not your district either has a parent mentor available. That's somebody who's employed by the district to help parents navigate special education issues, or whether or not the coalition, the Ohio Coalition for the Education of Children with Disabilities, can help you in some way. They often refer people to that agency as well. So, and then they can describe the available remedies. Okay, so we do believe this is a violation. What should you do about it now? And then what remedies might be available. Remedies are things like compensatory education or additional minutes that can be provided to you. So what's available if you were to exercise any of these alternative dispute resolution procedures? So definitely a really good support through ODE. And again, there are occasions that we've called them because we're unclear about an issue, and they're very helpful to both parents and educators when you call the office. Now, facilitation, also, I wouldn't say it's underused, but I think worth its availability for sure. So facilitation is where a neutral third party, typically it can be somebody who also acts as a mediator. ODE has individuals who work as mediators, and they may also work as facilitators, but they're both trained in the same way. So the Office for Exceptional Children will provide the training for this person. It's a neutral third party. And here's where the situation that I like to use a facilitator is where maybe the relationship has broken down a little bit, or broken down just over this one issue. And again, with any of these tools, you don't have to have an attorney, and especially with facilitation and mediation, it's not absolutely necessary that you have an attorney. And facilitation, I would say, you can absolutely use, without any advocate or attorney involved. And that's where they're helpful, because the facilitator will attend an IEP meeting, might attend a planning meeting or an ETR meeting, and just help guide the meeting in a way that's productive and focused on the student. Because if the relationship has broken down, or something happened in the past where there's some resentment between the parties, the facilitator will just keep it on track, and also remind the parties, what IDEA says about this, what the operating standards say about it. So they really, they do help. They don't make decisions for you, and it's not binding. It's not like they go in there and say, twist your arm to do what the district is telling you to do. If you ultimately decide that you don't want to, do what the district is saying that you should do, even if the facilitator suggest that you should, it's not binding in any way. It's not like the facilitator comes in there and makes decisions for the parties. Now, it can ultimately end up in a written agreement between the parties, or maybe even typically more often with facilitation documented on the PRO1 that the parties agreed to this, or are willing to do X, Y, and Z. So it can end up in a binding agreement, because that is binding if the parties agree and you document it. But it doesn't necessarily have to. It more often in mediation will end up in a written agreement. And that written agreement, if there is one in facilitation, again, is just typically part of the IEP or prior written notice form, as opposed to an actual written agreement that's enforceable in court. But it is binding if the facilitator comes in there and gets the parties to agree. It is binding. Let me just take a look at the chat and see if
I got it covered.
Okay, got it.
And as with facilitation, I do believe that this is a really great tool that is offered to parents. And I think having a neutral third party who can listen to both sides and try to almost negotiate, right? Going from one side to the other, and they're saying this, what do you think about this? I think it definitely helps when you're at that point where there's just a breakdown in communication and there are definitely two opinions. So I have had really great results with facilitation. And like you had said, Mark, it is kind of underutilized. I don't think a lot of parents know that you can use a facilitator, or maybe a parent thinks that it's going to be, it's going to, again, break down that relationship. And I don't feel like it ever does. I think it helps, and I think it's beneficial, and both sides would agree that at that moment in time, a facilitator is a great tool to use. So I think that more parents should probably ask for a facilitator, and they're usually pretty quick with their turnaround too. If you contact ODE or tell the school district you want a facilitator, I mean, I'm seeing 2 to 3 weeks. It's not usually a long process.
Yeah, agreed. And the parties do have to agree. Both of them have to agree to use a facilitator, but I don't think I've ever had a district, that didn't want the facilitator there. I've had one in the past where they've had the same facilitator and decided, they didn't think it was a good idea, but we ultimately used her again. But yeah, but for the most part, districts are agreeable, if a parent wants a facilitator there, because honestly, on occasion too, the facilitator will identify to the parent that what they're asking for might be a little outside of the obligations of the school district. So they're helpful on both sides. So thank you for that, Danielle. And of course, I have to point out that they're free. I'm going to go through this whole series of tools and continue to point out that they're free, which is pretty remarkable. All right, mediation. Very similar to facilitation, although it doesn't take place in an IEP meeting or an ETR meeting or a planning meeting. It's a separate meeting they schedule, and you typically need a decision maker involved from the school district that might not be the special education director. So a lot of times a superintendent or a designee will be involved in a mediation. And most often I would say that the school would want their attorney there, their counsel, although not necessarily. I would say if the parent brings an attorney, typically the school's going to want an attorney there. But you, as a parent, you don't need to have an attorney in mediation. It is, again, a neutral third party, separately scheduled meeting, and they are trained in special education. So, and some of the backgrounds of the mediators and facilitators at OD are pretty impressive. What they've done with alternative dispute resolution and in special education. So it is not just some Joe Schmo that shows up and works between the parties. It's somebody who knows special education law. And then with mediation, again, separately scheduled. A lot of times it happens at the district, wherever it's convenient for the parties. Right now, it's all happening on Zoom, so that's even more convenient. And again, mediation or the mediator does not make decisions for the parties. The mediator will encourage parties to do what they're obligated to do under the law, or discourage parties from demanding things that the school is not obligated to do under the law. But if you ultimately disagree with the opinion of the mediator or the school in mediation, you can walk away. It's non-binding. It is a chance for the parties to resolve their conflicts. Now, if the parties can get to an agreement, on any of the terms or all of them, then that is typically memorialized in a written agreement. And I like one mediator in particular, won't let us leave unless we have the agreement written and signed. So we work it out right there, type it, print it, and sign it. I like that because we hash it out, and then if we leave the room and then a couple of days later have some misinterpretation of what the parties agreed to, then it's all, we're at a loss again, back to square one. And so I like hammering it out with the whole crew in the room in mediation. And that agreement is separate from the IEP, a little bit different than facilitation typically works. With mediation, you write an agreement that is a binding contract that would be enforceable at the common pleas court, right here in the county. So it also requires, typically, this is a little different from facilitation, is when you enter into any contract, there's typically a waiver of your claims. That means, hey, look, we're settling everything here at mediation, and in exchange for what we're going to give you, you're going to waive all the potential claims that you had prior to this day, not in advance. You can't go forward, but going back, you're saying, okay, we're resolving our differences here, and I'm not going to make any claim about anything that happened in the past, assuming you get what you want in the agreement. Obviously, again, you can walk away if you don't, like what you're getting, or you don't feel comfortable waiving the claims that you think you have that happened in the past. But that will happen. You will waive your claims in a written agreement in mediation if you get to an agreement and sign. So that in that case, it might be helpful to have an attorney present or have an attorney look over the agreement before you sign it, to make sure that you're not waiving anything, some hefty rights. But for the most part, again, generally speaking, it's you're waiving any right to file due process on something that happened in the past. You're waiving any right to file a claim in court. You're waiving any claims related to the subject matter at issue, or any claims that you would have under IDEA when you walk out of mediation. Now, you still have that new enforceable agreement. And if the school violates the agreement, or if the parent violates that agreement, you have a breach of contract action in the local court. And you also have most likely a violation of IDEA, assuming that the agreement was built around what the obligations of the parties are under the statute. So that's important to realize. But again, it's worth it. It's really, there's no risk, no harm, no foul if it doesn't work out. At least the parties get together in person or in Zoom and work out their problems. And that also sometimes can just help clarify what the issues are. One real problem right now, because meetings seem to be so fast, and districts are scheduling meetings in a half hour, sometimes even an hour is not enough to, really work through the issues or the concerns of the parent. One of the real problems is communication of what the parent thinks they want, or what the parent wants, and what the parent thinks they're entitled to. So sitting down at mediation, which is typically scheduled for a full day, definitely a half a day, usually, it forces the parties to put everything on the table. Like, what do you think you're entitled to here? Or what do you want? And can we do that? It's just like you're looking face to face, trying to get it worked out. So, it just, for the sake of communication, it's really good.
I was going to ask a quick question, Mark.
Yeah.
So if you're a parent and you're having a difficult time with a district, how would you choose between a facilitator and a mediator? Like, what would be, a driving force that would make someone jump over the facilitator and go straight to mediation?
Well, if you think the facilitation will definitely have the whole IEP team there. So if you think you have some people on your side on the IEP team, and maybe there's just one holdout, the facilitation might work. You just to have the facilitator. If you think the facilitator is going to agree with you too, then you get the whole IEP team in there, and typically ends up at least in an amendment of the IEP. Mediation, you're getting some other parties involved now, and you won't have the whole. Typically, you won't have the whole team there. You have to agree on who you want at the mediation, but you're not going to have the whole IEP team. So you might have the special education director. You'll probably have the superintendent, and you'll probably have the school's council. So, who's going to be better, you think? What's the best chance to get the decision you want, or to get to agreement? If the school's council is going to be involved. It might kind of force your hand a little bit to get counsel on your own. So mediation is kind of a step advanced in that way. But I would mediation does pull you away from the process you've been in for a little bit. So that we find that helpful, even when we're involved, to just request a mediation right off the bat, so that the parties can talk about what they're, again, get face to face. I'd say if you think the IEP team is close to consensus, then facilitation is probably the way to go.
Gotcha.
If you think you want to, if you want to remedy, this is another important part. If you think you're entitled to compensatory education or some compensation for, a reimbursement for tutoring that you provided that you thought the school should provide, or tuition or something like that, mediation is going to be the way to go, because you're not going to be able to get that type of agreement coming out of facilitation. The mediator, remember, you're creating a whole separate agreement in mediation typically, which can include those types of remedies: compensatory education, other types of compensation, additional parent training. So if the remedy you're seeking is unique, I think mediation is certainly the way to go.
Gotcha. Thank you.
Yep. Okay. Next, we're going to talk about formal written complaints, and then move on to due process, which I know most people have heard of. So the formal written complaint has its place and it has its advantages. So some people refer to this as a state complaint. The difference is this one, the formal written complaint, is just that. It's written. You don't typically appear anywhere in person, although the investigator can talk to the parties in person, but the ODE prefers to do it by telephone. So if they can get all the questions and answers they need by telephone, they'll do it. So the advantage there is that you don't have to appear in person, before the school and make the argument. You're doing that on paper. You're submitting it to an investigator at ODE, and they're going to investigate it, and then call you for clarification, call the district for a response and clarification, and then ultimately issue findings. And some in the findings, when they do that, they have to do it within 60 days. So that I like the timeline on a written complaint, because it has to be resolved relatively quickly. But in the findings, if there is a violation of IDEA, they include corrective action for the district. That tells the district what they have to do. And if they're not in compliance, then ultimately, the big threat is they'll withhold funding, state or federal funding, for special education if they don't do what the corrective action says they have to do. So so it does get you a result relatively quickly on paper without you having to appear. It's less adversarial because you're not appearing in person and making the arguments in front of somebody at the school. 60 days is a good, I think, a quick timeline, all things considered. You kind of cut to the chase, and there's a form online at ODE's website for both there's forms, I should say, to request facilitation, to request mediation, to file a written complaint, and then to file due process. And I would absolutely encourage all parents just to use the form. You don't have to be creative. I mean, the form has slots for everything you need to make the complaint sufficient, so that it won't be dismissed. And as long as you fill it out, and it's not a long form, honestly, as long as you fill it out and submit it, then your complaint's going to be sufficient, assuming you you allege something that was a violation of IDEA. So there are some real advantages. State complaints are good when the law is clearly on your side. If you say the school's doing this, and IDEA or the operating standards say that they should do this in this situation. So because then you're just putting it on paper. Facts and the law. Here it is. Please investigate this and tell me if there's a violation. And that doesn't mean that you have to cite the law. Specifically with these written complaints and due process, you don't have to cite to IDEA or be an attorney, or even you copy and paste from somebody else's brief. If you just tell them what the school district is doing and tell them that you think that's wrong, that's typically enough. Now, if it's not a violation of IDEA, it's ultimately not going to work. But you don't have to write in attorney language on these complaints. You just have to say what's happening and why you think it's wrong. But it is helpful if you can get to the rule. Well, I talked about that with, calling ODE. They'll help you get to the rule. And when we get to due process too, I'll show you how to look up the rule, so that if you can point to a part of the statutes that are violated or the regulations that are violated, it helps a lot. But you don't absolutely have to do that to file a written complaint. Now, some limitations on the written complaint is that it's limited to, it's a 1-year statute of limitations. So you can only allege violations that occurred within the past year. That doesn't mean that you can't talk about anything that happened prior to a year ago, because some of that may be relevant, when they first had their, first got on an IEP, when they first started receiving, these speech services. Those things are relevant. It's not like they're just going to preclude them from any consideration. But you can't allege a violation that occurred more than 1 year ago. So if the change, let me think of a good example. So if they denied speech services for a period of a month and then started continuing those, and that was 1.5 years ago, and you file a state complaint about that, it's not going to last. It'll be dismissed because they don't have jurisdiction to hear anything with a written complaint. That's important. From farther than a year back. Now, there are some things that happen that are continuing violations, like an improper placement, or a continued denial of, therapy services, or a lack of providing all of the required services. That is a continuing violation. If it started over 1 year ago, but it's continuing, then you'll have a basis to file on that because it's continuing within the year time frame that you can file on. The reason that's a disadvantage is because with due process, you get 2 years. Now, with the written complaint, you have 1. And then the other kind of limitation is there's no appeal of an outcome here. So if they issue a letter of findings and say, sorry, no violations, or maybe a violation of one of the 4 things that you alleged here, they'll issue corrective action for the one thing, and the other things are resolved, except, I say there's no appeal for this. I mean, there's no administrative appeal through ODE, and you can't file an appeal in court based on the findings of a written complaint. But you can file due process. So that's like your appeal if you disagree with the outcome of a written complaint. You still have the ability to file a due process complaint. And if you can't do both on the same issues at the same time. So if you file a due process complaint and a written complaint and they're about the same stuff, they'll put the written complaint on pause until the due process issue is resolved. And if the due process issue resolves what was alleged in the written complaint, then they'll just accept or take the outcome of the due process complaint, assuming it was about the same stuff and the same student. And I should back up too. Again, you can write a written complaint yourself using the form. You can use an advocate can help you do that. The OCECD or DRO can help you do that. So that absolutely does not require an attorney. Attorneys can help you with that, but they're not required. So it's less expensive. If you do hire an advocate or an attorney, you're not entitled to any reimbursement for that for a written complaint. Just know that it is a less expensive option, but you do have to pay your own way in that regard with a written complaint. The same is true with the due process complaint, but I'll talk about the occasion where you may be able to collect attorney fees in a minute. So a due process complaint is more akin to a trial. It's really the district's offering of a hearing on the issue that you're raising. So if you make a written request for due process, it triggers, first of all, a timeline. I said there's a 60-day timeline on the written complaint, but with due process, I'll talk about it, 75 days ultimately. But it does trigger an in-person hearing. So we're talking now about presenting evidence, presenting witnesses, things are going to be done under oath, and there's going to be a hearing officer. It's called an IHO, assigned independent hearing officer, who will hear the matter and make a binding decision. So Ohio is a two-tier state. So the due process hearing is technically at the district level. It can happen at the district, or it can happen at ODE or some other third party place. But it's technically the district level offering a hearing, but it's done by an impartial hearing officer. I think I said independent. Impartial hearing officer is who hears the due process complaint. And what happens very first is there's a resolution meeting, and that meeting has to take place within 15 days, and the parties have to participate. The school attorney can't be there if the parent does not have an attorney at the resolution meeting only. And a facilitator may be provided for the resolution meeting. It's more of a procedural meeting, although you can resolve the case there, if the conversation lends it to that. If both parties don't want the resolution, they can't waive it. But if the district wants to attend, and the parent has to attend. But again, if both parties want to waive the resolution meeting, they can do that. It just means that they feel like they're fully informed of the process, and they don't think there's a chance they're going to resolve it in the resolution. So that has to happen within 15 days. The parties can mediate instead if they'd rather just have a mediator there and do a mediation instead of the resolution meeting. That happens a lot. But all of that has to be done within the the first 30 days. After 30 days, unless the parties extend it, then following the 30 days, there's a 45-day window for the case to be heard and the decision to be issued. So you're really talking about 30 plus 45, 75 days total to get the thing resolved, assuming you don't resolve it in mediation or the facilitation. I'm sorry, the resolution meeting. Advantages of due process complaint. Gets the parties in front of each other for sure. You typically need counsel, although you can proceed without counsel. But I'll say the district's attorney will be involved, and they will try to get your complaint dismissed. That's the first thing they'll do. They'll say it's insufficient, it doesn't allege violation of the law, or they'll say you didn't do X, Y, or Z appropriately in filing your complaint. They will try to get it dismissed. The procedure is important, and the hearing officer that's assigned, the IHO, can't really help. You understand the procedure. If you feel pretty confident that you can make it through, you can do it, and parents have successfully made it through due process and won on their own without an attorney. But it is more complicated, more akin to a trial. Again, you're introducing evidence and witnesses, and there are some rules surrounding that would have to be followed. You do have 2 years when you're talking about due process, so it has to be in a violation. Just like I mentioned, 1 year with the state complaint, you have 2 years of when the alleged violation was known or should have been known to file a due process complaint. And there is a form for this too, so it's not like you have to come up with some magic legal language to draft a due process complaint either. The ODE has a form. Advocates can't represent you, although they can support you, and in some cases be witnesses in the due process hearing. In a lot of cases, I should say, be witnesses in a due process hearing. All right.
Mark, if you want to take a breath. So
Yeah.
I got a chat going. Eileen, I'm hoping can answer that question. But there is a question in Q&A that I
Okay.
come with. So Denise wants to know, what is the best way to get student advocate fees paid by the district? District has already admitted they dropped the ball.
Well, you're going to have to do that through negotiation with the district. And if they pay that, if they really messed up, they might consider it. But generally speaking, they will not pay advocate fees. If the advocate had to get involved and clearly identified that the school was violating, the statute, then they may consider it as an alternative to you filing a complaint. But for the most part, you have to negotiate it. So mediation might be the best way. because also going through a state complaint or a due process complaint, the hearing officer doesn't have the ability to, doesn't have the authority to pay advocate fees. We'll talk in a minute about attorney fees for due process, but for advocate fees, they have to be negotiated. So you have to make a pretty compelling case in mediation or some private negotiation with the district that advocate fees should be paid. And your advocate might be able to help you out with that. If it's an alternative to something worse, like a due process complaint, they might consider it. That's where a mediator or mediation might help.
We've had a luck in one mediation to have that occur, but I know it's rare.
Yeah. In regards to appeals of a due process complaint, so it's a two-tier state, and the initial kind of district level is the impartial hearing officer. Then you can appeal that outcome to a state level officer or state hearing officer, and they really review the record. They can have additional hearings if necessary, and if they and they really just identify whether there were any procedural errors or whether or not the impartial hearing officer at the district level abused his or her discretion in making the decisions that they made. So it's kind of a review of the due process hearing that happened, and can or cannot be beneficial. It just depends on the situation. But then if you're not happy with the state level review, that appeal, so independent hearing officer, state hearing officer, you can appeal to court. So this is state or federal court. Most people go to federal court because we're dealing with the federal statute. Unless it's uniquely, regarding the operating standards, you can go to state court too. But then you can file a complaint or appeal ultimately in federal court. That is more of a kind of a start over where they may have additional hearings. They'll certainly review the record down below. It still is considered an appeal, however, where they're looking at the procedure and what happened in the due process hearing to make sure that it was fair and impartial. That's really what they're looking at when you appeal to state or federal court in due process. I mentioned attorney fees a second ago. Attorney fees are available if you are the prevailing party in due process. Now, what's interesting about that, first of all, you have to go through the whole hearing, and it can be several $1,000s, tens of thousands of dollars, sometimes more, depending on how complex it is, to go through the hearing and pay counsel to do that. And if you have an advocate involved, paying an advocate, and you typically need to have expert witnesses, like psychologists and so forth, to testify. That's very expensive to go through, not convenient unless you have pro se counsel. I'm sorry, pro bono counsel. And so if you are the prevailing party, which means that you won, basically, then you can petition the court to have your attorney fees paid by the school. Now, that seems pretty straightforward, but a lot of people have the misconception that, okay, if you win at due process, the district writes you a check for whatever your attorney fees was. It's a lot more complicated than that. Although, it is a very valuable tool to use, where some people wouldn't be able to afford to go to due process unless they felt pretty good that they were going to win and get their attorney fees back. So it is, a nice tool, but it's not as straightforward as a lot of people think it is. You got to petition the court. First of all, there's always a question and argument by the school district that you weren't the prevailing party, which you'd think, well, either I won or I didn't. Well, let's say there's 4 issues or 5 issues and you won on 2 of them. Are you the prevailing party? I mean, yeah. Or if you were the prevailing party on 2 of them, do we then pay 2/5 of your attorney fees? And then and there are occasions, by the way, if you bring a claim, or you or your attorney bring a claim in due process and continue to litigate it, that's frivolous and not based in the law, that the school would be entitled for you to pay their attorney fees, which you can imagine how much those cost. So if you win on 2/5 of the claim, I mean, there's always some argument in a court. It's a separate proceeding where you have to identify that you were the prevailing party. and then get the court to make a decision about what your fees were and what's reasonable. Some other factors that go into that in terms of what's a prevailing rate for a special education attorney, what is whether or not the school made an offer to you sometime during the course of the proceedings that was in excess of what you ultimately won, then they can reduce your fee. So it's not as straightforward. Again, it's available. And of course, attorneys, special education attorneys who do due process know how to petition the court for the fees and ultimately get them. But it's not just cut and dry. The other thing is that's important to recognize is that a lot of times, if you get to a decision in due process, the attorneys for the school and the parent will ultimately negotiate an amount that they'll pay for attorney fees. That way you don't have to petition the court and go through that proceeding. That can happen too. And by the way, that can happen, if you go to mediation and you've used an attorney for a period of time, in a negotiated agreement, the school can agree to pay whatever they think is appropriate. So you can negotiate your attorney fees, even if you have an attorney involved in your IEP meetings. Through mediation, you can negotiate the school to pay. Again, you have to convince them, just like the advocate situation we talked about a minute ago. You have to convince the school that you wouldn't have got an attorney involved but for their violations of IDEA and the denial of FAPE. But all the way through the process, even after the decision in due process and on appeal, you can negotiate an amount for your attorney fees that the parties can get into. That's I'd say 95% of the time how it happens, although you can get them awarded to you by the court if you're the prevailing party as well.
We have another question, Mark, if you want.
Yeah.
Okay. So Jody asked, are you seeing exceptions to decisions recently due to restrictions or issues caused by the pandemic, like staffing issues, for instance?
Yeah, districts are getting more discretion. However, it's pretty clear that if there's been a denial of FAPE or services, that the student is entitled to those services. So I think they're given discretion in where and how often and when meetings are held, and they're given discretion in things like PRO1 and in-person instruction. However, if there's a denial, then the law is pretty straightforward and hasn't been amended to say that that would be a violation, and then there's consequences: compensatory education, make-up minutes, compensation if the parents have spent money on tutoring, things like that. I think they're given a lot of discretion, but if it, when rubber meets the road, ultimately, I think the decision would likely go in the favor of the parent because nothing's changed. The law hasn't been amended.
Well, an ODE even came out, when the pandemic hit, stating that school districts were still responsible for providing the services on the IEP, regardless of what the pandemic had caused. But I will say, in practice, it's hard when you're sitting in a meeting and the school is trying to get an aid or, whatever it may be, and they just can't. They post it and no one's taken the bait. So I don't like, I've been in many situations, I think, during the pandemic where, you want to give some leniency to the school because, they're trying and their hands are tied. You see the transportation issues all across the state. What are you going to do? ODE can come in and say the school district should be doing X, Y, and Z, but if the staff is not there, what are you going to do? So I don't know. I think that, I think you have to be lenient in some of these situations. Now, you never want it to cause undue harm to the child, of course, but I do think there has to be some leniency with what is going on, especially with staffing nowadays, because again, the state can't force people to take that job.
Yeah. I mean, that's a very valid point that, I know Columbus City Schools just canceled school yesterday because they didn't have bus drivers. I mean, it's just a practical problem. I mean, and, for some of those students who get the transportation as part of the IEP, that's a technical violation. I mean, so, and yeah, I think there is that. And I think it goes a long way when parents do give schools a little leniency and issues like that. And they're, hold off. I think the spirit going into the pandemic, and as we got about midway through, hopefully we're at least past midway, was that schools would work with parents to provide those. First, it was called recovery services, and now compensatory education and makeup minutes and all of those things. And I think in large part, parents are being reasonable and schools are trying their best to make it up. Now the pandemic's continuing, and now in person is a little tougher again. So I think in large part it can be, but I would say if it ever escalates and you have a basis to file a complaint, for the most part, you might get compensatory education as a result or a remedy in that complaint. But again, the practicality is, like, if they don't have another speech therapist, they might just violate either the corrective action, or what the new written agreement would be through mediation, or the decision and due process. I mean, so there is a practicality. It's like, we can only do so much with the people we have.
Right. I will say, I think schools are being very flexible and providing those extra services that weren't received because of whatever it may be. Now kids are being quarantined and they're out of school for, a week, 2 weeks. I have one family who's had to be quarantined several times. Family members have had COVID on, random times. You have the flu. And so I think school districts are being flexible and providing those services after the fact to make up those minutes. So I think it's definitely worth asking your district if you feel like your child is missing minutes because of staffing on their end or illnesses on your end. And I think a lot of districts are willing to provide that.
Yeah, a little grace does go a long way there from parents, if you can make it through now and hope to get it on the back end and be reasonable about that. So yeah, very good point. So jurisdictional limits, this is important. Of course, ways that these are reasons your complaint would be dismissed. First of all, you're outside the time limit, either on a 1-year state complaint or a 2-year due process. They don't investigate discrimination issues, none of facilitation, mediation, state complaint, due process. They're not going to help you with discrimination related issues. So ADA or Section 504 issues, the jurisdiction for those comes under the U.S. Department of Education Office for Civil Rights. So the State Department of Education just doesn't have funding to help you with those issues. Now, if they're intertwined, that goes really for all of these things. If they're intertwined with what's on the IEP, then they will look into them, or maybe make it part of the alternative dispute resolution. But for the most part, if you just allege a 504 violation, or that your child was discriminated against because of their disability, that complaint will be dismissed. No extracurricular issues, unless again they're tied. They can be accommodations for extracurriculars do fall under the ADA. So generally speaking, they're not going to be able to be heard through this process. But if they are somehow tied to the IEP, if there are accommodations on the IEP or otherwise that touch on extracurriculars, then they do have the jurisdiction to hear them. Same with athletic eligibility. Now, eligibility itself, they'll just be hands off. They're not going to deal with the high school athletic association. They're not going to deal with what the school standard for athletic eligibility is. But that's just outside the bounds of what they do. And then bullying, same thing. Typically, bullying is not under the jurisdiction of the Department of Education through facilitation, mediation, due process, or written complaint. However, if bullying ultimately leads to a violation of FAPE, then maybe it's an issue that they look into. But they're not looking into whether or not another child bullied your child and what should happen to that other student. They're not investigating bullying. They're seeing whether or not the failure to address bullying on the part of the school led to a denial of FAPE. So those are just some things to understand when you're using these alternative dispute resolution procedures. Practical pointers. Get to the rule. We talked about that. A couple ways to do that, and we'll be a little short on time, but if you look at the legal clinic page, that's www.lawyers4students.com/legal clinic. There's a research page at the bottom for parents. And from that research page, there's a link to due process decisions and state complaint decisions, that is a gold mine of information. You just click in there, and if you just click on the decision, you can even select by hearing officer, you can select by issue, or you can just select to see all the recent decisions. And then they're categorized by issue. So you can look, so if you had an issue dealing with extended school year, ESY, for instance, you can look at all the complaints. What's really cool about that is that when these hearing officers issue their decisions, they start with the law that applies. So there you have the authority for an issue for ESY. So it'll take you right to the statute, the operating standards or IDEA. Or, if it's an outside placement, they'll analyze the whole issue. Like, here's how we analyze an outside placement. So you can go, it's such a gold mine. We use it all the time, and it just helps you get to the rule. And of course, if you have access to the operating standards or IDEA, that's another kind of the old-fashioned way to go look up the rule. Be collaborative. That's kind of what we just talked about here. Even if this is dispute resolution, but it doesn't have to be adversarial, and it shouldn't be. You disagree with an interpretation of the law, period. And look, we're parents to our students, so we have to model good behavior. If we go in there, hot-headed and arguing, and especially if the student is involved in the IEP meeting and or mediation and so forth, they probably would be involved in a due process hearing. Then you have to model good behavior, and it usually works in your favor, which is why we suggest it. Use the whole spectrum of tools. You can go right through the list if you need to. You'd have to have some patience to go all the way through, probably a year just to go all the way through. But you can also jump to one that you think might be more advantageous because of who's involved. And then always, I would say, get help with due process if you're going to go there. And that is the summary of dispute resolution. Any pending questions?
I've got one that just popped up.
Okay.
You put the link in the answer box. So I put lawyersforstudents.com. I know I feel like you said like a / something that I didn't catch either. So I don't know if you want to say that verbally.
Yeah, it's at the bottom of that slide right there.
Oh, there it is. Perfect.
And that is, I'm glad you mentioned that. So I mentioned this is the seventh, kind of the seventh and final workshop in the series, but we're going to post very soon the next series of workshops, which again, I think are going to be provided by the coalition. And those will be on Monday evenings starting in February. They're not up there yet, but at that same link, we're going to have that posted very soon. And that's where the registration for the next workshop is. Because we don't have it available today, we'll send everybody an email reminder that if they want to sign up for the next workshop between now and February, they can do that, and we'll send them the link to do that. The other thing that's there, Danielle, I think is what you're asking about, is at the bottom of the page, you click on research portal for parents, and that's where you get to lots of good information, but in particular, you can get to the database of due process decisions and state complaint decisions that have been issued over the last several years from ODE. And then this workshop, like I mentioned at the beginning, is recorded, and we'll post this recording as soon as it's downloaded today. It'll be up there within an hour or so after our workshop ends today.
And then Jody wanted to know if there was any chance that someone could consult with her after this meeting. I don't know if any of the other agencies have openings.
So we do have individual guidance sessions. There's 3 rooms with 2 slots each. So we have an 11 and 11:30. Those are all full for today. However, at that same link, you can sign up for an individual guidance session, and the next one will be February. The alternative to that is you could contact the coalition and see either the coalition or an information specialist a program specialist at ODE through that telephone number I provided, and see if they can help you in the meantime. But the February openings, we should have 2 or 3 rooms in February that will be open, and she can register if you could drop your email address in the chat box or the Q&A, then we'll make sure that you get the link when those rooms become available.
Are we still doing Q&A after this?
We can open it up right now for question and answer, but it'll just be me and you, Danielle.
Right, very true. But I didn't know if that was also an option though for Jody. If she just had a couple questions, we'll be here to answer them if you would like to join us. So we'll just stay on and then you can hang out.
Right. If you'd prefer a confidential session, then you can do it in February. But otherwise, yeah, we can try to answer some. We'll stay on for another 5 or 10 minutes here and see if anyone else has any questions.
So Denise had asked if she can register for next month. So we're starting in, oh yeah, February is next month. Oh my goodness, where am I at?
Yeah. Everyone that signed up to attend today, we will because we don't have the schedule yet and what the workshop is going to be for February. So everyone that attended today, including you, Denise, will get an email with the link to register for next month, but it'll come in over the next week.
All right, I think that's all we have for questions.
All right. Well, thanks a lot, Danielle. Hope you have a good weekend.
Thank you so much. You too.
Thanks everyone for attending. See you next month.